Okay, guys, everybody. So we are on break right now, and this is what happened earlier this morning. It's a feed that does okay for us to do a feed after the fact, nothing live. This is what happened this morning. We are currently on break. So I want to share with you guys what happened this morning. Hi, everybody. Please hit the like button and share. Share. Hit the like button and share. Good morning. How are you doing? Hey guys, just sharing with you guys what happened this morning in court. Still waiting. He hasn't done the other part.
All right. Superior Court of Fulton County now in session. Judge, you're Chief Judge, you're black representative.
Good morning, ladies and gentlemen. Please be seated.
Edward.
Okay. That way. There we go.
All right, guys, the motions are going to be handled this morning. The judge is on a break right now, so they get ready to hear the first motion. This is from this morning right here.
Those teas not coffee. Those teas not coffee.
I need to. I was like, you know, this hour.
I didn't see no coffee up there, so right. It's not so much. It's like tea. I'm mad at you. That's right. Really? You want that one either? Yeah. He's from,
All right, good morning, councils, interested parties. We are ready to commence, or at least be back on the record in the matter of the state of Georgia versus Khalif Adams et al. In 22 SC 183572. Let me go ahead and tell everybody good morning to begin with. Let's go ahead and take roll. Mr. Beebe and Mr. Partridge. All right, good morning. Mr. Stillwell, Mr. Botts, and Mr. Sharp. Good morning, gentlemen.
Good morning, Judge.
Mr. Farley and Miss Vereen, is that correct? Or Mr. Farley, you're back. Okay, I mean, Mr. Menace, you're back. Okay, all right. Good morning, sir. All right, Mr. Williams, Mr. Steele, Mr. Adams, gentlemen, good morning. Mr. Mender and Ms. Fagan, good morning. Mr. Kendrick, and let's see, Mr. Weinstein, good morning.
Good morning, Brian.
Mr. Huey and Mr. Matthews, good morning. Mr. Myrick and Ms. Bernard, good morning. Mr. Nichols, Mr. Harvey, Ms. Westmoreland, and Mr. Gardner, good morning. Mr. Adams and Ms. Callan, good morning. Mr. Blaylock and Mr. Hill, good morning. Where's Mr.
Good morning, Judge. I'm so sorry.
I didn't mean to interrupt you, you know, from when, you know, that deep concentration you're having, but good morning, sir. All right. That's okay. Don't worry about it.
Mr. Hill is parking. He should be in your mom's.
Oblivious don't
Oh,
start
I'm glad
today.
he's got it like that.
Oblivious don't start.
Okay, Mr. Blaylock, you okay with that, sir? Okay, thank you, sir. Mr. Dorsey and Mr. Jimenez, good morning.
Good morning.
All right. Mr. Eppinger, Mr. Johnson, good morning. All right. And Mr. Ryan and Ms. D. Williams, good morning. All right. Okay, folks, Ms. Battle, come on up. Thank you. Councils, before we go ahead and take up this motion, let me tell you what's going on in the background. You know that Ms. Von Kelch and her team have the next series of 100 jurors, and that would be 614 through 714, who are here today to fill out questionnaires and hardships. So that is going on as we speak. So we're going to take up a couple of matters while that's going on, and depending upon what time we have left in the morning, we will then either do a few hardships if we can, and then if not, we will take up the bulk of them this afternoon. So, but the issue I wanted to kind of cover with you to begin with is I have a juror 661, who is currently outside and has been brought to the court's attention. He is a young man. I don't have the, like I said, we don't have the information about our jurors as of yet. That hasn't been passed out. But the young man has, he's here with his mother. He was here with his mother on Friday when we did our initial introduction, orientation, and then playing of the video. But he has mental health challenges. Those are ADD, oppositional defiant disorder, bipolar, and ADD. And he's been very disruptive on Friday and today. I would just ask for your concurrence to go ahead and excuse him right now. 661. Any objection?
State has no objection, Your Honor. No, sir.
Okay. Ms. Battle, you can tell Ms. Von Kelch that 661 can be excused at this point in time, please. Okay, thank you, madam. Our jury clerk, and she reported that to me. She reported that to me on Friday, that he was already here. And, you know, they tell everyone at that point in time that we have to go through the examination. But as I understand it, his mom was outside the entire time because we couldn't have her in here with it in the jury selection, but she brought him back this morning. Okay? All right. Yeah. Okay. Okay, the matter I'd like to take up right now is the motion to sever filed by the state. Ms. Love, I believe that you have asked the court to consider to sever at this point in time two defendants, those being Mr. Mender, who is represented by Ms. Fagan, and as well as I gotta get the right page. Please bear with me. Mr. Adams, who's represented by Ms. Callen. Is that correct?
It is.
Okay, all right. If you could tell me why I need to go ahead and consider that, and I'll let the aforementioned attorneys and their clients then respond. Here you go, Edward.
Thank you, Your Honor. Your Honor, I believe that a little background is necessary before we get into the motion. A few weeks ago, the state and Fagan.
Hold on. Yeah, use the microphone, Ms. Love, if you wouldn't mind, so everybody can hear you through the audio system. Ladies, you can have a seat.
Thank you, Judge.
All right, madam, try again.
Thank you. By way of background, a few weeks ago, the state and Ms. Fagan spoke to the court, and Ms. Fagan apprised the court of an intended leave of absence that is, in fact, imminent around the month of June. Today, I think she actually filed a leave of absence, noticing the court that she will be absent from June through August. On that same date, Ms. Callen apprised the court of an impending and imminent leave of absence that she too will face, but her leave will be in the month of July, beginning in July. This conversation, Your Honor, took place sometime in the month of the latter part of January. And on, I believe it was February the 13th, the court instructed the state to place in writing any motions that we had regarding the matter and to speak with defense counsel to determine what defense counsel intended to do as it relates to their intended leave. The state had inquired previously of both counsels for defendant Adams and defendant Mender whether they intended to secure backup counsel, and that is counsel that can fully represent their client's interests during their absence with no conflict. When we spoke with the court initially, both Ms. Fagan and Ms. Callen intimated that neither of their client.
Okay, what's the like number looking like, guys? What's the looking up like? Are they hitting the like button? If I don't get enough likes, I'm gonna end this. Like 27 likes. Okay, y'all, I'm about to go because these people wasting my time. And I'll come back later on tonight and show the footage. Because I asked for the like button to hit, and they playing games with me. But I'll see you guys later on tonight. I decided to you have 60 viewers and more than half. If I want way more than half, then that's what I want. Don't tell me what I should have and what I should do. I've taken the time to get over here to show you guys the least you can do is hit the button. People are always trying to tell me what to do. Isn't that funny? They're not here. They're not over here trying to get the information. They're always trying to tell me what to do. It's pretty sad. It's called supply and demand. The supply is low, demand is high. No, I'm not loosen up. I'm not gonna loosen up. No. Yeah, can I ask y'all something? Why do y'all always try to tell me how to run my show? How? Why? Why?
Unknown caller.
To represent.
Which is their right.
That is absolutely correct.
Okay.
And so when I spoke with both Ms. Callan and Ms. Fagan on the 13th, as the court instructed, my inquiry was twofold, whether or not it was still their client's position that they would not seek to have any backup counsel, and whether they saw a circumstance where they each would see themselves completing this trial to verdict. At that time, they both, again, reinforced their client's right to the counsel of each client's choosing, and stated that they would not be securing any backup counsel. And both stated that the state's only option, as they had previously stated to the court, was to make them an offer that their client would accept or sever their clients from this trial.
To that end, did you talk with our elected district attorney and apprise her and potentially, because of course plea negotiations work both ways, so.
Absolutely right, Your Honor. And
Okay.
to be clear, the state did present defendant Mender with what we believe was a very generous offer, and he turned it down. The court actually made inquiries of Mr. Mender, whether this is in fact what he wanted to do, and he has every right to turn that down.
That was before we commenced the trial.
That's correct.
Memory
We
serves
were,
me correctly.
we were in that place.
Okay. All right. And still his right to do so.
Right.
Okay.
And Ms. Callan informed the state in the hallway that there was no need to extend an offer to Mr. Adams unless such an offer included a modification of the life sentence he is currently serving for murder. And I informed her that would not
Statutorily,
happen.
that's not possible.
Exactly.
Okay.
And so as they both have stated that the only two options that the court has is to, or the only two options available are to extend an offer that their client will accept or to sever their clients from this trial. We are at a point where we have made our best offer, and we don't have an offer that will include a modification of a life sentence for murder. And so our motion was simply, given those announcements to the state, was simply that the court exercise its discretion and before jeopardy attached and for judicial economy, sever out the two defendants whose attorneys would be unable to complete the trial to verdict without interruption.
Yes, ma'am. Okay. Thank you. I'll hear from Miss Fagan. You can go first, madam. And if you come up to the podium. Ms. Callan, you can remain. You're welcome to come up and stand next to Ms. Fagan if you like, or you're welcome to have a seat. I'll invite you up individually. Ms. Fagan, on behalf of Mr. Mender, does that kind of summarize where you are at this point in time?
Some of it. So the most recent conversation was about 2 weeks ago.
With whom?
With the state.
Okay, all right, okay.
So this is what I'm requesting. My request is to hold a severance until the April 28th date for 2 reasons. One is, Your Honor then at that point, we'll have another 600 jurors that we've examined for hardship and possible agreement for cause. And at that point, I think Your Honor said that you were looking to qualify 500 to 600 to get into individual questioning. If at that point we haven't gotten into individual questioning, potentially my client wouldn't have an issue with someone sitting in for me during jury selection. He does not want anyone representing him for opening statements or for case in chief.
Okay, you understand the issue is that we don't know when, well, I've told counsels this as long as I've been a jurist and even when I was a practicing attorney. Mother Nature is not somebody that I can bargain with. And while we are all thrilled that you are in this particular status and wish you all the best, you won't know what date you actually need to take leave, and then I don't know how long you're going to be out for. And there are a lot of unknown variables that I can't kind of give you with granularity, because we also, as you know, we'll be picking jury, probably screening first and second level well into May at that point in time. So we should have, if all works out, a jury by early summer. But I don't know what your plans are. I don't know if you, in terms of your leaves, are you planning to take leave or take FMLA?
So the leave I filed was for June 5th until August 25th. And so if the court's order for having the last 300 coming in middle of May,
Like May.
Then I would expect individual questioning to start in beginning of June, and then potentially being able to make it to opening statements.
When are you? Yeah, it's going to depend. I mean, because it's going to take, I would say, like I told you all, it will probably take the better part of.
Okay, what I'm gonna do, y'all, I'm gonna hit my hotspot because Wi-Fi sucks. Wi-Fi sucks in here. I'm gonna hit my hotspot. Hold on a second. I'm gonna go into the room and hit my hotspot. I'm gonna put on my hotspot. Just 1 second. Hold on, yeah, I'm trying to get my hotspot. Now it's better. I can go back out. Do not use sound from jurors. He's telling me do not use your.
The wife that always are always struggling to find movies to watch. I'm gonna have to find out. Oh, that was that's a shocking. Oh, that's classic. Now, it's really good. Well, I like an animated. You have one time. Know that? It's crazy. Oh yeah, you know, they drag him out of the world. I just completely. I hope it's.
All right, guys, let's go. We're gonna do this. We're gonna try this again.
2 to 4 months to actually complete that process, depending upon how long it takes you all to examine jurors. As I mentioned, a kind of a guide mark for the APS case. I told you is they examine about 3 people a day. That'll take 4 months.
Right. So that's why I'm requesting to.
And if you do a panel, it's 2.5 months. So, but do you have somebody lined up that would facilitate that particular issue if
It wasn't frozen.
to cover you during this particular period of time?
I've been talking to 2 people now about only for covering for jury selection. So that's why I'm requesting to not have the court issue an order until the April 28th day, when Your Honor has the next group of hardships coming in after the March date. So at that point, you'll have 600 people in, and I think then we'll have a better guideline of whether or not this can work timeline wise.
Okay. All right. All right, madam. And your client, from talking with him, he only wants you to represent him for the purposes of trial commencing, and that would be defined by you as opening statements and continuing with the trial.
Yes, Your Honor.
What about if we start before then?
So in early August.
You say we start,
Right.
I mean, 'cause that's why, I don't know. And I also don't know what's gonna, I'm gonna pray for you that you have a uneventful, birth experience and that you are otherwise healthy and everything else. But we're gonna, there's so many factors. I just don't, I don't know. To contend with that are unknown. So, I think that's a reasonable ask at this point in time. You can give us a little bit more information on the 28th of April and to make some decisions. So
Thank you.
I think that's more than fair given what is going on at this point in time and the timeline that we have. Okay.
Thank you.
All right. Mr. Mender, are you okay with that? Okay. All right. Ms. Callan, come on up.
Good morning.
Good morning.
Tiana Callan on behalf of Mr. Khalif Adams. Your Honor, I am joining in on the response provided by Ms. Attorney Fagan. My client is similarly situated in a sense where we would pretty much be okay with having stand-in counsel while jury selection is ongoing and once it's completed.
Have you identified anybody?
Your Honor, we're still in talks about that. We're still exploring our options and seeing what the scope of representation will look like and whether or not my client will consent to that. But it's just right now just a matter of conversation.
Okay, all right. Go ahead. I'm sorry. I meant to hijack you. So I wanted to ask about your standby counsel, but go ahead, madam.
Your Honor, it's just a matter of conversation that I have to have with my client. So I don't have any names for you today, but it's something that I could absolutely get when necessary.
So if I hear you, what you're saying that he wishes to adopt the same position as Ms. Fagan for me to hold this until April the 28th. It is when are you taking your leaves, madam?
It would be at the end of June.
Through what date?
Your Honor, what?
If you don't have any specific dates
I don't have
right
any
now,
specific dates
then
right
you can
now.
tell me, in April, if that's the case.
That would be better.
Okay, all right. So you owe us, what dates in April, that you plan on taking leave, okay?
Yes, Your Honor.
And the other thing I would ask that you do is that both you and Ms. Fagan should have identified somebody in particular that will in fact serve, and you should be able to proffer to me. I'll have to do a little bit of examination with you and your client, Ms. Fagan. This applies to you as well. On that third part, on whoever it is that you've identified, they're going to have to come in. I'm going to have to examine them on the record about their willingness to take that scope of representation, and then each one of your clients would have to agree and concur to that.
Okay.
Okay, so that's what I would do on or around the 20th. I'll book some time after that April 28th date for us to have another conversation about this. Okay.
All right. Thank you, Your Honor.
All right, Ms. Love. Anything else, madam?
Thank you, Judge. The state has no objection to the court withholding that inquiry until the April 28th date. We would just ask that at that time that the court ensures that if backup counsel has been identified, that the court inquire whether backup counsel would be able to continue to represent each defendant in the event of some unforeseen occurrence beyond just the jury selection phase.
Yes, ma'am. But that's the court's concern as well, Ms. Fagan, as well as Ms. Callan. If your clients are saying that if something should happen and they don't want anybody but you, that changes the severance posture. So I hope that they understand that, and because if they're not willing to bargain, if they're not willing to say I'm okay with that scope of representation, then of course that's going to depend upon what happens. So we can inquire into that at that point in time.
Yes, Your Honor.
Okay.
Thank you. And considering that the subject of backup counsel was where the state started, we have no further commentary or requests of the court.
Okay, all right. So I'll identify a date after the jurors that come in. I just wanted to make sure counsels, what I'll do is, and you all can please remind me, I'll make a note that at some time during the first week or two of May, we will have this second conversation and continue it at that point in time. So attorneys Fagan and Callan, you'll just have to have identified that backup counsel and have them available for our next inquiry for us to talk, okay?
Yes, Your Honor. Thank you.
All right, Ms. Callan, you okay with that, madam? Okay, all right, okay, all right. All right, thank you very much. That concludes that issue. Okay.
All right, guys, that is it for now. That is it for now. I will be coming back later on with the continuation for the hearing, what he has for us. And he is still on the break, so I will see you guys later. And I hope you guys not selfish with the likes. All right, this is how we get the stuff broadcasted out. So I'll see you guys in a You. All right. Have a good one. Bye.